May it please your lordship.
Yes.
My lord, with the consent of the addressed, my lord, I beg to mention item number 1 and 2, my lord.
Why?
My lordship, in this matter, additional,
There was an in last date, Mr. Mazumdar stated that he was to withdraw. What happened?
lordship, he has some personal difficulty today, but he has instructed me to inform this honorable court that the government has taken a decision that they want to argue this matter on married man.
Okay.
Lordship, may kindly fix the matter on Monday, my lord.
No, my lord, I have some difficulties. Can it be in the first week of October?
Okay. A request is made on behalf of Additional Advocate General Ms. Mazumdar that the state government no longer proposes to has not given any further instruction regarding withdrawal of the appeals, and that the appeal would have to be contested. Appeals would have to be contested on merits. A short accommodation is sought so that the matters can be argued. Denotify on 5th October as per.
Deeply obliged, my lord.
May I please, Lord? May I please, Lord? Lordship, I beg to mention item number 6, Lordship.
Why?
This matter may be taken up on Thursday, Lordship.
Why? Why not today?
Because engaged advocate is busy, Lordship, out of station, Lordship, some personal difficulties, Lordship. So,
What is the matter about?
Lordship, this matter is, we have filed the appeal in a limited grounds, your lordship. Actually, what happened, lordship, I have been given the contract, lordship, and it was terminated without communicating me, lordship. Further, the contract was awarded to someone else, and within 2 days, lordship, of they have given, lordship, they have released 1.91 crores of lordship, that matter, lordship. We have now the authorities are in connivance with everyone is trying to release the
Counsel
rest
for
of the money also,
A
lordship.
request is made on behalf of the private respondent to adjourn the matter as the arguing counsel is not available today. Re-notify on 21st September as per
31st September, lordship.
21st.
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 Lordship, 21st, lordship, actually my senior lordship, he will be in the Supreme Court, lordship, either in this week or maybe,
Then it goes to October.
lordship, maybe in the first week of October, lordship, on third.
No, not on first week, not in the first week.
There is some-
17th October.
Lordship, there is, lordship with my, lordship with this, I apologize.
We gave you the accommodation, not beyond that. Okay. 17th October.
Lordship.
May it please your lordship. As regard item number, my lord, 11, your lordship. I have not received my memo of appeal, your lordship.
There is a judgment of this court which covers the controversy.
Lordship, no, lordship.
Why?
Here, the respondent belongs to
Rajasthan.
And section 1026.
From that area, that area would refer to a domicile of the same area.
Section schedule 7 also 6 is also come to play. Lordship, as per section 20.
So what about the judgment which is relied upon
Lordship,
by learned single judge?
Lordship, the petitioners were belong to Northeast, Lordship.
Okay, that makes a difference.
Yes, Lordship.
Learned counsel Mr. Kale shall supply a copy of the memo of appeal to learned counsel Mr. Goel representing the respondent. Re-notify on.
First week October, your lordship.
Okay, 4th October.
Lordship, much.
Wait, please, your lordship. I beg to mention item number 12. Actually, I'm counsel for the petitioner. We have filed reply on affidavit to opposition today. It is not brought on record. I mean, kindly be allowed to bring it on
The
record.
counsel for the petitioner has filed affidavit in reply. The same be brought on record. Re-notify after 2 weeks.
Thanks, your lordship.
May I please, Lordship? Well, the APSC batch matters, those are fixed for hearing tomorrow. But in the list, tomorrow's list has come. I have not seen. I'm led by the.
They will be listed. There is some error by the registry.
Okay.
They are already,
Additional aging he has landed.
they'll be listed.
Lord.
Yeah.
May I please, your lordship? My lord, I am praying for a listing of a new writ appeal on Friday, my lord. Deeply obliged.
May it please, your lordship. My lord, writ appeal, my lord, on Thursday, my lord.
What is the matter about?
My lord, it is a tender matter, my lord.
Okay, Thursday.
Deeply obliged.
May I please, your lordship, I beg to mention writ petition of 4471 of 17. It was last received on 3/9 of 2018. Can it be taken up on Friday?
18.
Yes, lordship.
After 2018, it has not been listed.
No, lordship.
Find out. Find out. We'll find out.
Can it be taken up on Friday then?
Just wait. Let's find out why it has not been listed. Then we'll see.
Obliged.
Daily list for orders, item 7 and 8, along with item 21 of supplementary list.
May I please, your lordship? Lordship, item number 7, we have instructions to withdraw the appeal. lordship.
Withdraw.
File an
There is an application affidavit.
We have filed
the-
an affidavit to the effect, lordship.
An affidavit has been filed on sworn by the appellant. Affidavit sworn by the appellant dated so and so has been filed, indicating that the appellant is no longer desirous of continuing with this appeal and wants to withdraw the same. Hence, the instant writ appeal is disposed of as withdrawn. All pending applications are also disposed of.
Obliged, lordship.
Lordship, the interim order passed, I may be vacated.
The interim order passed earlier stands vacated.
I am deeply obliged, my lord. Similar in item number 21, my lord.
21 also, there is a prayer for withdrawal.
My lord.
Eight.
Oh, eight.
What's happening?
Eight to four.
Let's check. That is an IA. What is that IA about? In view of the fact that the writ appeal has been disposed of as withdrawn, comma, the interlocutory application is also disposed of.
I am deeply obliged, my lord.
I already likha diya na. All pending applications are also disposed.
Deeply obliged, my lord.
That will cover this also. It also, all pending applications. Number likh dena. All pending applications, IA number so and so, so and so.
My lord, 8 also analogous, my lord. This is supplementary petition, this analogous, my lord. Withdrawal, my lord. 8.
There were 2 writ appeals, my lord.
8 also you want to withdraw.
Withdrawal, my lord.
Same order in 8 also. So
Complete.
then 2 appeals, separate orders.
My lord, we have liberty to file a fresh, my lord. That liberty, my lord.
Why liberty? There was some tough queries which were posed.
Yes, my lord.
After that, this withdrawal request has come.
Certain
We can very well decide on merits.
certain circumstances, that is why. my lord.
Nothing.
All right.
There was some kind of incorrect statements being made.
My lord.
Yes. I am deeply obliged, my
Interim
lord.
orders would stand vacated, my lord.
The
Already.
affidavits have been filed by appellants in writ appeal number 257 and 149 seeking withdrawal of the appeals. Hence, the writ appeals as well as all pending applications are disposed of. Interim orders disposed of as withdrawn. Interim orders operating earlier, passed earlier, are vacated.
Deeply obliged.
Deeply obliged, lordship.
Item number 10,
May I please, your lordships?
Hmm.
Lordship, impugn order is
Denial of interim relief.
my lords.
What is the scope of interlocutory appeal against denial of
Actually,
interim relief?
before I take a lordship to the order, may I state some brief facts of this matter, my lord? My lord, in the year 2020, my lord, an advertisement was issued thereby for appointment of the post of principal in Barama HSC School, my lord, wherein I participated and the private respondent had also participated, my lord. And thereafter, I was appointed as the regular principal. Thereafter, in fact, earlier they had filed a writ petition in the year 2020, saying, presuming, my lord, that I may be appointed as a regular principal and I don't have the valid B.Ed degree. During the pendency of the writ petition, again in the year 2021, they filed another writ petition, my lord. They were saying that they were not allowed the allotted marks. And as such, the private respondent, if she had been allowed to given the allotted marks, my lord, she would have become the first allotted principal, my lord. So, during the pendency of that case also, again in the year 2023, they filed another writ petition. They were challenging the order of the director, whereby the director had passed an order, thereby saying that I have the valid B.Ed degree by law, and as such I was allowed to hold the post of principal minor. The 3 writ petitions, and thereafter in 26/6/2023, the 3 writ petitions were disposed of by a single order, Your Lordship. Therefore, the Honorable Justice has passed an order, therefore directing the director to consider the findings of the IS minor. Taking into ground. On that, after taking into that consideration, Your Lordship, the director has passed fresh order on 27/7 July minor. Therefore, saying that I don't have a valid degree. Challenging the same, I have filed a writ petition.
So let the writ petition be decided, validity or otherwise of your degree will be decided by the learned single judge. If you succeed, you will become the regular principal.
My lord.
If you don't, you
My lord.
don't have the qualification.
My lord, one thing is this, my lord, that the question is
Which
whether
is the body which decides the validity of your
it will be
B.Ed?
if it is validity, my lord, then it will be the Guwahati University who will have
So
the
Guwahati University has never given that
No,
opinion.
my lord.
So let that opinion come.
I did not have any objection whatsoever, my lord.
Then-
But the question is this, my lord. What the private respondent is saying that I didn't take the prior permission. 2 things are there. If the Guwahati University tomorrow says that I have a valid degree, then also they will come up with can say that I don't have taken the prior permission. This is the crux of the matter, my lord. The permission is there, my lord.
You claim to have gained this B.Ed degree simultaneously at the same time while you are serving elsewhere.
My lord.
So how is it practically possible?
My lord, there, first of all, the OM, may I kindly take your lordship to page 70, my
Come to
lord.
para 2 of the order,
My lord.
page number 4. Taking note of the factual aspect that the SDB college teachers education TU from where the petitioner had taken the B.Ed degree course does not have the evening shift to impart B.Ed degree, and therefore under what circumstances it was possible for the petitioner to undertake the B.Ed degree course by attending the day classes in the Brahma Higher Secondary School, which is located in another place.
I'm coming,
So,
my lord, I'm coming to that.
yes,
Before your lordship, I'd like to take your lordship.
Mr. Counsel, we'd like to tell you
My lord,
that if you take our opinion now,
my lord.
it may prejudice the writ petition itself. Fate of the writ petition would be impacted by our decision. So rather than agitate a cause against an interim order, request the learned single judge to expedite the disposal of your petition.
I've only simple prayer, my lord, that I don't have any objection if the Guwahati
You can't
University-
have any objection.
My lord.
Yes.
But I just saying, my lord, no subsequent order has been passed thereafter after passing the order of the single judge, my lord. Therefore, I may be allowed to hold the post, my lord, because I'm a regular appointed principal, my lord. And the
If your
permission-
B.Ed degree is by itself under a cloud of doubt, how can you be allowed to hold a post of?
I'm coming to that, my lord. I've taken the permission, my lord. Your lordship may kindly peruse the page 49, my lord. This is my permission, my lord.
You have double pagination in your paper book, gentlemen.
One is for the writ petition, my lord, and one is writ appeal, my lord. I didn't change it. For page 49,
Yes, 49.
my lord. My lord, this is a letter to the inspector of schools by the principal of the Barama HS school, my lord.
27 July 23. No.
15 July, my lord. 15 July 2014, my lord.
Anyhow, then we'll issue notice in your appeal.
Why
Issue notice to the respondents. We'll hear them in the steps for appearing.
private respondent is appearing, my lord. Private respondent is appearing,
You already represented
my lord.
all the private respondents.
Only one private respondent is there, my lord.
Who are appearing for the response numbers 1 to 5.
Copy has already been
University?
served, my lord. Copy has already been served.
What university was appearing?
Copy has been served, my lord.
To whom?
The standing counsel of the Guwahati University, my lord.
What is the name, gentlemen?
Mr. Fugon, my lord. TJ Fugon. PJ Fukan.
PJ Fukan. Is his name reflected?
No, my lord.
Then obviously,
GU is there, my lord.
you should notice name of standing council. BTC who's there? You are appearing, standing council GU, Mr. So-and-so shall be reflected in the call list. Private, there is a private respondent as well. Steps for service on the private respondent number so-and-so be taken in 3 days, whereafter process be issued to such respondent. Who is appearing for the respondents numbers 8 and 9? No one. Steps for service upon the respondents numbers 8, 9 and 10. 7 NCT, you are appearing? NCT is also not represented. Upon the respondents number 7 to 10 be taken in 3 days, whereafter process be issued. Not 10 colleagues. Rule is made returnable in 4 weeks.
Item number 13.
Also, in this case, I have received instructions last night, Lordship. After the verification, Lordship, in fact, some quantum of this magnesium carbonate is found in the samples. And there are some gray areas in the law. So I'd like to file an affidavit. And in the meantime, 2, 3 high courts have also decided this issue, and one matter is pending before the Supreme Court. So I am trying to collect all those judgments. And 1 week's time may be given to file the affidavit.
Please for.
I'm appearing on now this control, although you will issue notice. Information notice because the Delhi High Court, the past, the append the notification which was banned, banning the farmers. The matter recently went to the Supreme Court and Supreme Court stayed the judgment and appellate notification. So with all those issues, we can also bring to the notice of lawsuit, we can also issue notice.
Issue notice to the respondents.
Decided in favor of the manufacturers. But the magnesium carbonate, they have said that this is not a total ban, the percentage will not, is beyond that, it's not there.
In some items, it is permitted.
You'll also issue notice of that, we may.
Issue notice to the other respondents as well.
5 to 11.
The response numbers 5 to 11. Steps, Dr. Ashok Saraf, senior advocate, appears for the respondent number 11. The steps for service on the other respondents be taken within 3 days, whereafter process be issued. Advocate General may file affidavit on behalf of the state authorities in the intervening period. Rule is made returnable in 4 weeks.
Date may kindly be fixed, my lord.
Re-notify on 7th November.
Highly obliged.
Leave it.
Item number 14 to 16.
Dr. Saraf has ensured that at least the pan masala distributors will enrich some lawyers, if not he himself.
My friend is very happy now.
Overjoyed, we would say.
Personally affected person will.
Credit goes to me, your lordship.
Definitely, Mr. Goyal.
I'm obliged, no?
You received the record, Mr. Kalita?
Lordship, unfortunately, I could not lay my hands on the records. But anyways, Lordship, I don't want to wait for that. We would like to go ahead with this. Lordship.
Okay. What are the matters? Can you tell us? Yes, please. Proceed.
My lord, my prayer is confined to 3 points, which is enclosed here as Annex 2. May I go through?
Yes, please. Page number
Page number 48.
48, yes.
48. Point number 1. This above case arose from the illegal and void land acquisition of the petitioner's residential lands by the respondents, page 40. By the respondents for the extension or improvement of roads from Farcon village to Tekte in the year 2010. Point number 2, the petitioners have filed the WPC number 98 of 2014, and it was dismissed white order dated 1/7/2015. On appeal, white WA 1 of 2016, the Honorable Division Bench at the Guwahati High Court was pleased to admit the case, and white the judgment order dated 37/2018, WA 1 number 1 of 2016 was disposed.
Can we have a look at the judgment?
Judgment is here.
Let's see, page number.
It's about 311 units.
Hmm.
It is a 311.
Yes, please. So, Mr. Counsel,
My lord,
are you not asking us to review that just same judgment? Is it writ appeal were the very same which you are now making? Is it right?
please mention again.
What prayers you made in that writ appeal, they are virtually now being repeated in the present writ appeal.
Yes,
Is it right?
beginning.
So
Right
now
from-
what is the reason that we should indulge in that review of the earlier order of the division bench?
Because, my lord, my prayer is threefold right from the start in
Mhm.
2014.
Okay. So the division bench gave you liberty to make a representation.
Make a representation.
What is the fate of your representation? Same order was passed by Honorable Supreme Court, right?
Honorable Supreme Court gave us the liberty to approach the
Authorities.
Mm.
Yes. So now what is the order on your representation? What order was passed on your representation?
Please take page impugn order. Page 46.
46.
Yes, this is the impugn order of the district magistrate, district collector of Champai.
Yes.
May I go through?
Mm.
In the matter of judgment and order dated 37/2018, read appeal number 1 of 2016, with read appeal 9 of 2018, Mr. So-and-so, the division bench of the Guwahati High Court directed the appellants to make a representation before the district deputy commissioner, Champai, raising their claims for further compensation, and upon such application being made to the deputy commissioner, shall examine the matter as to whether the appellants are entitled to any compensation for the possession of the land in question, and accordingly pass a reasoned order in compliance with the direction of the Honorable Guwahati High Court. Opportunity was given to the appellants to make representation before the undersigned.
Mhm.
They were represented by learned counsel for the appellants, who submitted the documents of their claim.
Next para.
On thorough examination of their representation, no valid document was produced by the appellants to prove their title over the land and whether they were in legal possession of the land. Further, they could not establish how much area of land was claimed to be in their possession, for how long the land was in their possession, and in what capacity they were occupying the said land. The district administration did not act strictly strictly in accordance with the LA Act 1894. As the occupants of the land didn't have any legal claim over land, and it is mandatory to produce legal documents of ownership of land in order to follow the LA Act. There is no record of preliminary notification issued under the Section 4. No declaration was issued under Section 6, and no award was made under Section 11 of the LA Act 1894 by the district collector. This office acted merely as a facilitator in public interest for the exchange of land from the willing occupants to BRTF in league of the money offered as compensation for the vegetation of bill structures. It was ensured that the interest of the villagers of Mizoram was protected and no rights was violated. The cost of vegetation was assessed per the market value of the produce for 1 year, and the cost assessment of the structure built on land was done as per the then existing local market rate. The assessment was jointly conducted by this office, the occupants of the land, and the BRTF in the presence of the village council. The total amount of compensation was rupees so and so, was released to the BRTF by demand draft bearing so and so and dated so and so, and this amount was disbursed to 31 occupants. Subsequent to claims for additional compensation, in accordance, an account payee check bearing number so and so, dated so and so, amounting to rupees so and so, was given to DC, who disbursed the amount to the 13 occupants.
Mr. Kalita, what you argued before the learned single judge, that there is a concealment of fact, that as a matter of fact fortifies their claim. For the reason that the moment you yourself come out with a case that some of the appellants herein were granted compensation, you recognize their right. And it is an admitted position that you have taken over the land without following the procedure of law. What is the fate now?
That is true, Lord. That has been reflected in the division bench, earlier division bench.
So then what is the fate of that acquisition?
Order also.
You have to quantify and pay the compensation as per the Act of 2013. That is the only consequence.
No, 13, Lordship, there is another.
All right, to 1894, assuming it, because it was done. But since there was no acquisition under the 1894 Act,
No, Lordship.
now what will be saved?
The Lordship, yeah, Lordship is very correct, saying that like couple of things are undisputed, Lordship. Lordship, as far as like 1894 Act was not taken into account.
So then now if you want to make an assessment, it has to be done under the 13 Act.
The 13 Act, Lordship, there is a problem there because 13 Act is already, there are two cases, Lordship, which are pending before this honorable court, whereby, Lordship, there is 10 has been taken, the 2013 Act, which is a central act, that is not applicable to Mizoram because of that
All right. Okay.
130
So-
71G.
Okay.
So that is already pending before this.
Okay,
honorable
okay.
court. But Lordship, in this case, Lordship, I'll just take your Lordship to a couple of things, but before.
Yes,
Lordship,
sure, sure.
Lordship, first of all, Lordship, I'll take your Lordship to the first case that they have filed. That is a page 141, that petition, Lordship, the prayer portion only, Lordship, I'll just point out. 141, that's third here, Lordship.
Yes.
So initial prayer in that initial petition, like after this acquisition, That lordship is will find at page 150, your lordship.
150.
Yes.
150.
So first
They
one,
claim compensation under the 13 Act.
yeah, they were basically seeking for the number 3, your lordship will find, be pleased to direct order respondents to pay petitioners a solution
Solicium.
of 100% and an interest of 12% for 4 years.
Yes.
And they said that 2013 Act should be brought into.
Mm.
Now, lordship, this was dismissed on the ground. Lordship will find the judgment at page 1. Page 115. Lordship, 1 second, lordship. I'll just give the page number. Page 191, your lordship. It starts from page 191.
Mm.
So I will take your lordship directly to the relevant paragraph.
Mm.
Page 194, your lordship.
Mm.
194, for bottom paragraph, lordship. I have considered the submission of the councils. The circulars dated so and so issued by the district administration officer only reiterates section 3 of Lusai Hills House Site Act 1953. Herein and referred to as 1953 Act. Section 3 of the 1953.
Their claims were rejected on the ground that they could not produce documents.
Documents because there was a bar. They are saying that there was a bar by these notifications that giving this house permissions or cultivation.
But you yourself recognize their rights, sir,
But that has
by granting them compensation, your own case.
Yes, Lord.
So if you acknowledge their rights over the land in question as owners, possessors, occupiers, whatever it is, then the compensation has to be assessed in a formal manner, which exercise was never done.
The exercise has been done as way, lordship, that representatives
Without any notification,
village council people were there. They were there.
Ms.
Their
Kalita,
was there.
Ms. Kalita, everyone was there. So distribute whatever comes to hand.
Oh, Lordship, I'll come to that, Lordship. I'll come to the.
Come to the legality of your action,
I'll
please.
come to your Lordship. But only that last, I'll skip your Lordship. So basically, this judgment says that like since there was no land document, there was nothing. So they were not.
Act of 1894 recognizes the right of an occupier also. And you, by granting them compensation, acknowledge that right. Now, this Act of 1956 would not override the provisions of the Act of 1894.
Now, Lordship, only thing, Lordship, as your Lordship has pointed out, whether it can be reviewed now. That is the point, Lordship, I would like to ask.
No, nothing to review. The revision bench gave them liberty to represent. They have represented. You have rejected their representation. So that is a fresh cause of action.
Lordship, I take your Lordship to the judgment and order of the division bench, Lordship. What was the confinement of the judgment, Lordship? Because that was challenged before, that point was raised before the division bench also. As far as LA Act 1894 or LA Act 13, those points were raised before the division bench also earlier.
Yes.
So that's so, Lordship, page 311.
Yes.
Lordship may come to directly to page 315, Lordship. May I request your Lordship?
Yes.
315.
Come to para 10 first.
Paragraph
Para 10.
10 years. May I read out your Lordship?
Yes.
The said compilation of block development officer gives a prima facie indication that the appellants were assessed and paid compensation in respect of their residential houses standing over the land, which again is a prima facie indication that they were in possession of the land, although they may not have produced any land passes for the same. The expression person interested as appearing in section 3B and 18 of the Act 1894 had been interpreted that it be given a liberal construction so as to embrace all persons who may directly or indirectly interested in title of the land or in quantum of compensation. 11, Lordship. The compilation of cost of residential block development officer, it can be inferred that compensation in respect of the value of the residential structure standing upon the lands of the appellants have been assessed and paid, but no such compensation have been assessed for the value of the land which was apparently under the possession of the appellants. Considering the liberal interpretation of the expression person interested as interpreted by the Supreme Court,
we are of the considered view that the appellant also has a legal right, their legal
So
right.
the right of the appellants has been recognized, Mr. Kalida.
Yes, that has.
The
been-
right has been recognized, and the court also says they have a right to get the value of the land under their occupation to be assessed.
Correct. That is.
You
correct.
never made that assessment.
That I don't dispute. Your
Then-
lordship. Now, lordship, like that paragraph 12, your lordship,
Hmm.
paragraph 12,
Yes. What is the letter dated 21/5?
lordship.
What are the contents of this letter dated 12/5, 21/5?
21/5 lordship, there was a development of issuing land passes and.
So the court says irrespective of the fact that land passes were not issued, but still for the occupancy, they were entitled to some kind of compensation, which you have not paid.
Now, question is, lordship, compensation under what, lordship? Compensation under which act? And like
1894,
in this case, lordship, in the division bench, lordship, I'll just take it also, I'll take.
we have read the judgment.
Lordship, just 13 days. 13
Yes.
Not 13, lordship. In view of the above, appellants are directed to make representation before the Deputy Commissioner Champai, raising their claim for a further compensation, and upon such application being made, the Deputy.
So it has
Commissioner-
been confined to possession of land. That is the confinement made, possession of land. Now argue,
Now, lordship, after this, lordship, what has happened, that lordship has already seen that impugn order was passed by the Deputy Commissioner.
that no land
Rejecting
documents.
rejecting that.
Yes.
Then thereafter, they have again come before this honorable court. Now, only thing is that, lordship, whether like the same issue, I mean.
It's
as far
not a
as-
same issue.
the-
The
as far
court
as-
says the only thing which is now required, requires adjudication is whether on the part, on the aspect of possession of land, they are entitled to claim any compensation. That is the only thing. Buildings, etc., they have been given compensation.
They have already.
For the-
been given.
Their possession on the land in question, any compensation is to be paid or not.
Lordship.
That is what is to be seen.
So lordship, as far as lordship 2013 applicability, that lordship may not.
Maybe,
that-
maybe, that's right.
That will
Yes.
be problematic because 1894 lordship, of course, at that point of time, 1894 was
Yes,
applicable.
yes, yes.
So that lordship can.
You say that the writ petitions pertaining to the applicability of 2013 are pending.
Pending, because lordship, what has happened, the state has brought out another act of state act of land acquisition in 2016.
Hmm,
So there was a challenge whether 2013 can be made applicable or not.
applicable.
Because our argument before this honorable court was that it cannot be because.
Those appeals are still pending,
It is still pending.
pending here or in Aizol.
In this branch, in this court.
My lord,
So
my,
numbers are, I have with me, sir.
Just hold on, what he wants to say.
my lord. In the month of December 2015,
Hmm.
16th of December, when the governor passed an ordinance regarding this, it was myself who challenged the impugn ordinance. But then the ordinance lapsed, and therefore my petition also got in first class.
It was an ordinance.
Yes,
There is no act thereafter.
thereafter, when the assembly sat, I informed the opposition parties
Hmm,
to raise an objection regarding this.
hmm.
And they formed a committee comprising of 7 members. Then the committee, one of the committee member, he happened to be the then minister, MLA, sitting MLA, K. Becho. He took suggestions from me. We sat together after.
We appreciate what you have done, but fact remains there is an act thereafter.
No, Lordship, what I want to say is,
Yes.
he asked me whether I am satisfied. I said, I am not satisfied. I will challenge this.
Hmm.
But then they secured the governor's permission. They did not secure the president's signature.
Have you challenged the act of 2016? Is it under challenge? What additional advocate general says is that challenge to the act of 2016 is pending before this court. No, what your argument is, there are twofold arguments. First is grant us compensation for the land.
Yes, Lordship.
And secondly, assess the compensation under 2013 Act.
Yes, Lordship.
So that issue, whether the compensation should be calculated under the 2013 Act or the 2016 Act, or it should be done under the 1894 Act. That is pending before this court. So we will, what we propose is, we'll admit your appeals and connect them with those appeals, pending appeals. Is it okay? Because unless that issue is adjudicated, we cannot proceed to make an assessment how your compensation will be quantified.
Lordship, this act, association and reassociation falls under Schedule 7, item number 42 in the concurrent list.
We are not examining the validity of this act in this writ appeal, at least that is for sure.
Oh, Lordship.
That is not under challenge, right? So when the validity of that is already, this court is in session of that challenge to the validity. Let us tag your appeals with those appeals or their petitions.
Yes, sir.
Once that issue is decided, finally we will have to take a decision under what provision of law will the assessment be made. Do you understand?
Yes, Lordship, and then one more submission. This Act 1894, amended Act 1984 was repealed under section 114 of the new Act.
New Act.
Under subclause 2,
Yes.
it says, read with the General Clauses Act,
Yes.
my cause survives.
We are not ousting you on this aspect that your cause does not survive. We are not at all saying that. What we are saying is, still the controversy as to which act will apply to the state of Mizoram, that is pending consideration of this court. So unless those matters are decided, how can we give a direction to the state to make an assessment of your claims? Under which law? You tell us, all right. Which law would apply?
Under the 2013 new Act.
That's what we are saying. That challenge is there in this court that is pending. You get what we are saying?
Yes,
You
Lordship.
understand? So we'll admit your appeals. We'll tag it, these appeals for the limited purpose that once that challenge is decided, fate of those petitions is known to everyone. Then we will decide under what provision of law will your claim lie.
Lordship, may I submit one?
Yes, yes.
Please grant me time for filing, challenging this.
That you can very well file a fresh petition. There is no difficulty.
Thank you, Lordship.
Admit issue notice. The respondents are duly represented. Thus, process need not be issued. Mr. Kalita, then additional Advocate General, Mr. Kalita points out that petitions laying a challenge to the validity of so and so Act 2016 are pending consideration of this court. In this background, we feel it just and proper to tag the files of these writ appeals with our pending consideration in the principal seat Guwahati High Court. We feel that the fate of those petitions will have an important bearing on the outcome of these writ appeals. Thus, these writ appeals shall also be tagged with so and so.
Oblige.
In the meantime, then Counsel Mr. Joseph submits that he is desirous of challenging the vires of the Act of 2016. He is free to do so by taking recourse before the appropriate forum.
Thank you, my Lord.
Okay.
Item number 17 to 20.
On the earlier occasion, Lordship, I made a submission that the government wants some direction, and Lordship was pleased to direct me to file an IA. That note is being prepared, Lordship. It has not come to me.
Okay.
So we are going to file it. Kindly give us 2 weeks time to file your IA.
Item number 19, my lord. I filed an application for vacating the interim order on 6 December 2021, my lord. At least that may be hard, my lord, if possible.
What is the controversy? Please refresh our memory. What is the controversy involved? Mr. Sai?
Controversy is lordship, there are some allegations that in tribal blocks and bales lordship, non-tribal people are settling there.
Okay.
So that is the area.
Okay.
For protection of the tribal people, lordship, this exercise was undertaken.
Okay.
Lordship, so far item number 20 is concerned, our land is a patta land, lordship, and the non-tribals have encroached upon our land, lordship. So this is a different type of case, lordship, than that of others, lordship.
So you want that case to be separated?
No, let it be along with this.
Ms. Saikia and Advocate General Ms. Saikia submits that he needs some more time to file the formal application in terms of the liberty granted in terms of the proceedings dated 24th August 23. Re-notify on 18th October. Which is the matter, item number 19. You are appearing.
Lordship, I am for the appellant, I am for the petition, your lordship.
It's your writ petition.
It's my writ petition.
I filed an application.
What is the matter about?
Yes,
in
my
that?
lord. I filed an application vacating the interim
On behalf of?
on behalf of respondent number 5, my lord.
Let's
What
see.
happened, my lord, in the
Item
instant case, my lord? My humble submission before your lordship, my lord, the interim order passed by the learned single bench is contrary to the order passed by the division bench in Podut Kumar Bora case, my lord. Because Podut Kumar Bora
Interim order, this is a single bench writ petition.
single
Yes,
bench
lord.
petition,
Okay.
and my lord, there is an order of the division bench, my lord, of in Podut Kumar Bora stated that Subkamru belt and block, the land belonging to Subkamru belt and block should be, my lord, evicted immediately, my lord. And if the officer not complied the order, then action will be taken against that particular officers, my lord.
Pradyut Kumar Boda.
Yes, my lord. Podut Kumar Bora, my lord. Item number 17, my lord. Your lordship kindly go to the order dated. Order 9/12/2019 of the Podut Kumar Bora case, my lord.
Yes, just.
I have also given my lord judgment.
Yes, we have got a copy.
Yes, my lord. I have give the copy. Your lordship kindly come to the, my lord, inner page, my lord, 6, my lord. Wait. Inner page 6, my lord. Your
Six.
lordship, come to the point number 6 at the, my lord, bottom.
Kamrup M,
Kamrup
South
M.
Kamrup Tribal Belt.
Yes, my lord.
Yes.
Kamrup, South Kamrup, Tribal Belt, 1 to 4 bigha, my lord. That land, within that land, my lord, this land has been, my lord, situated. My learned friend has filed a writ petition and obtained the interim order. And they have lost this in the, my lord, Board of Revenue, my lord. Order of the Board of Revenue was not challenged. And my lord, in the, my lord, order of the circle officer has categorically stated, my lord, they have holding the tribal belt and block land. And most important thing is that, my lord, I have annexed the, my lord, drawing, my lord. He is filing the case under separate DAG number, my lord, DAG number 20, patta number 95. Whereas my land is DAG number 30 and patta number, my lord, DAG number 13.5 and patta number 30. Despite of that, my lord, they have enjoying the, my lord, on the basis of the stay order, they are not evicted, my lord. And my land has been taken, my lord. I want to show something, my lord. That your lordship kindly come to the writ petition, my lord.
Yes. Lordship, yesterday we have filed an additional affidavit, lordship, where we have brought in record, lordship, the earlier partners are no longer dead, lordship. All the new partners are all tribals, your lordship. All partners are all tribals, your lordship.
Okay, all partners are tribals.
Yes, lordship.
Okay.
So we have filed it yesterday, your lordship.
When was this composition changed?
Yes,
It was changed after this litigation?
yes, man.
Then
That is
that is an attempt to draw wool over the court's eyes?
that is true, your lordship. And regarding the pressing of the addition, my senior will like to press this additional affidavit, your lordship.
When?
Lordship, he's in another court since then, type, lordship.
All right, then come on 17th.
Yes, ma'am.
The other
Yes.
matter is fixed on 18th, your lordship.
18th, all right, 18th, 18th. It's 17th is a Sunday, 17th is a Sunday. So we'll- 19th,
19th, lordship.
20th, all right, 20th. Interim order pass and so and so shall continue till next.
Lordship, I have a apology clear, lordship. My senior will be not there in the month, in the week commencing from 19th of September, your lordship. Maybe after in the month of October, your lordship.
Then all right, come on 25th, 26th,
26th of September.
yes, 26th September.
Copy of the additional.
I'll
Copy.
keep, lordship. Somehow it just missed your lordship.
26th.
The interim will continue, your lordship.
Interim order pass and so and so shall continue till next.
Much of it.
Top of the list matters, item number 3 and 4.
Before my senior starts, my lord, I need some accommodation. There is a challenge of the rule of the GMC Act.
Hmm.
Also, we'll fix another date, my lord. With the for preparation is required.
Woodland Advocate General will be appearing. Since the petitions lay a challenge, these two petitions lay a challenge to the validity of certain provisions of the Guwahati Municipal Corporation Act 1969, then Advocate General, we request Learned Advocate General, Mr. Saikia, to assist the court in these proceedings. His name shall henceforth be reflected in the call list, re-notify on,
Let it be, my lord, on 28th September.
not in September, sir, not in September, no. Re-notify on 18th October,
Then, my lord, let it be later than 18th.
later, all right, November. 9th November. This should be done at the inception. If there is a challenge to the virus of that, Advocate General has to appear.
Yes.
It's 2018 matters. We think we should incorporate this instruction in the registry.
Initially, it was in the part 2 list, but it was mentioned by.
No, Part 2 is now, there is no part 2. All cases are in circulation.
Much of-
Item number 5.
Seventeenth, yeah, 18th. What is the date? 17th.
This appeal is preferred by SEBI, lordship.
Yes. It's okay. Yes.
We are aggrieved by the learned single judge's order, wherein the learned single judge was pleased to find that the form in which the so-cause notice was issued, it was not according to the law.
Mm.
7, 8 other issues were also framed, lordship.
Mm.
In fact, most of the issues were not pleaded case, but 2 issues came in favor of the SEBI, lordship,
Mm.
and the other 5 went in favor of the other side, the writ petitioner.
Mm.
If lordship is pleased to look at the so-cause notice,
Mm.
because that is the main challenge.
You have been given liberty to issue fresh notices.
Yes, lordship, but that is not required in view of my humble submission because the law is very well settled.
Okay, let's
The
see.
only thing that the learned single judge found that it is a notice under 4.1 and our notice said it is section 4, rule 4.
Mm.
Supreme Court in the recent judgment very clearly said in the so-cause notice, we have to mention about the penalty also, which is going to be imposed.
Mm.
That issue has created the problem before the learned single judge. Whether we can incorporate both in the same way or there should be a separate notice.
Separate notice, okay. That will be putting the cart before the horse.
Actually, the so-cause notice is, the procedure is very well laid now, lordship.
Let us see the notice.
Yes,
Let's see
notice.
the notice.
130.
And the act, please. SEBI Act.
In fact, in the repetition, my lord, I have given certain compilation. In those compilation, my relevant act, rules, everything has been given here. If records are there, my lord.
Yes.
May I please, page 131.
131.
notice dated 17 September 2021. Notice under Rule 4 of SEBI, Procedure of Holding Enquiry and Imposing Penalties Rules 1995, read with Section 15(1) of the SEBI Act of 1992 in respect of Ankita Didwani. I have to place it because that will clarify. This notice is important. The
Yes,
SEBI
yes.
herein after so and so, bearing pen number so and so, is for carrying out alleged non-genuine trade in liquid stock options at BSC Limited, thereby violating the provisions of Regulation 3, A, B, C, D, 4, etc., and unfair trading practice relating to security markets regulation of 2003. In this regard, the undersigned had been appointed as adjudicating officer on 6 July 2021 by SEBI under Section 19, read with Section 15(1) and Rule 3 of the SEBI procedures of 1995 to conduct the adjudication proceedings inter alia in respect of the notice, the manner specified in Rule 4 of the adjudicating rules, read with Section 15(1) and 2 of the SEBI Act. 3. SEBI observed that large-scale reversal of trades in stock options. These are the offenses.
Just,
Reversal of trades. So I'm coming.
just hold on.
I'm skipping all this now. Coming to page
131. Where is
136.
page 132?
It's
missing. No, it's here. It's here. Yes.
132.
Yes.
The various offenses. And Lordship will kindly come to page 136, serial number 14.
136. Yes.
With respect to above alleged violations, notice is hereby called upon to show cause as to why an enquiry should not be held against him in terms of Rule 4 of the SEBI Regulations 1995, read with Section 15(1) of the SEBI Act, and penalty should not be imposed in terms of Rule 5 of the said rules and the provisions of Section 15(h) of SEBI Act. Further, the notice may also note that a settlement mechanism is provided under SEBI Settlement Regulations 2018. If the noticee wishes to opt for the settlement process, they may apply for the same in the manner given in the aforesaid regulations under intimation to the undersigned. Further, they may note that filing of settlement application does not confer any right to seek settlement of the proceedings. Notices reply, if any, should reach the undersigned so and so at the address given below, through email, etc., within 14 days from the date of receipt of the notice, failing which it shall be presumed that the noticee has no reply to submit, and the matter would be further proceeded on the basis of the materials available on record in terms of Rule 4.7 of the adjudicating rules. Next page. The noticee is advised to provide copy of the PAN and email and keeping the undersigned informed about the change of its correspondent address, if any, till the proceedings are complete. This is also important from a different perspective. Now, whatever the documents we are supposed to give, Lordship, Annexure ABC, these documents we have furnished. So this is challenged basically on two grounds. What is the pleaded case? Those two grounds are, Lordship, that the adjudicating officer does not have the authority under the provisions of the rule. That is one. And there is a predetermination that their offense has been committed. Whether from the language of this act of
Notice.
this notice, whether that can be made out or not. In my humble submission, we have issued the notice, giving him the opportunity, her the opportunity to respond. If we are satisfied that there is no violation, then that will drop the whole proceedings. And if we found that this reply is not satisfactory, then there is a process under 4.3 to issue a phrase date, a notice intimating the phrase date of hearing. That stage has not come. So the whole procedure has been laid down in the rules of 4. There are several stages. Whatever mistake we have done, in my humble submission at the very beginning, I have to indicate that this notice, if Lordship is pleased to come to page 31.
131. 131 or 31?
131. Notice under Rule 4. It should have been notice under 4.1.
4.1.
The learned single judge, while framing the issues, also considered it as 4.1, not as 4. And learned single judge found finally that it is a composite notice under 4.1 and 4.3.
Right.
But while framing the notice, and our stand is very clear, it is a notice under 4.1, which the learned single judge also accepted while framing the issues. The issues, Lordship will kindly find at page 495. Although only 2 grounds were pleaded, several issues were framed here without there being pleadings. But I am not on that because some issues came in my favor also. But those are minor issues. The main issue is whether the circus notice was in proper
Format or not, format or not, yes.
Now, issue number 1, whether the grounds to believe, which is a condition precedent for initiating an investigation under section 11, did exist in the facts and circumstances in the present case. The judgment came in our favor because we have sufficient materials. B, whether the opinion to be formed under Rule 3 of PR 1995 is an individual opinion in respect of the person specified against whom the notices under 4.1 are to be issued, and if yes, whether such individual opinion has been formed. So from the records or from the affidavit, the learned singles has found that it is against us because there is no indication, although we might have formed the opinion. And as it was not the pleaded case, there was no requirement for us to produce the documents. Now the documents are with us.
But Mr. Saikia, what we can gather from the concluding part of this is just a cursory observation.
Lordship.
That you have been given liberty to issue fresh notice.
It has a very wide ramifications throughout the country. 1500
Presidential.
Exactly, Lordship.
Okay.
Exactly. So that is the reason why we have challenged. Otherwise, we could have rectified it. In every cases, we issue notice first, the 4.
So would it not be better that we admit the appeal and keep it pending?
It is.
This has not been admitted. Actually, we pointed out yesterday. Yesterday,
Then Lordship may be pleased to
we'll admit it
yes,
because otherwise also we noted that irregularity in the office proceedings.
Yes.
That the file has been listed for hearing without it being admitted.
Lordship, it may be admitted, Lord.
We'll admit it. After hearing the arguments advanced by learned senior counsel, Mr. Saikia, representing the appellant SEBI, and Mr. Goel, representing the respondents, the appeal is admitted. Admit, as the respondents are represented, process need not be issued. List for hearing in due course.
Maybe in the month of November, Lordship.
In the month of December.
Lordship, highly obliged, Lordship.
The judgment was, this is the common judgment, but appeal has been prepared against one.
Doesn't matter.
Other cases we have filed in some, all those cases will come whenever it comes, we'll
admit them and tag with
orders.
We actually pointed out to the office
Lord.
that a matter, unless it is admitted, it can't be listed.
Lord.
It's an error. As you say that it has a ramification countrywide.
Yes, Lord.
So let this
That
issue
is why
be
the judgment was
kept
taken.
alive because assuming that if at all the single by judgment is affirmed, it would have an impact everywhere.
Pan India.
So let it be thrashed out properly.
Lordship,
Then we'll see. Okay.
highly obliged.
Deeply.